scrutiny test and for illustrating when the strict scrutiny test applies, we are going to say that that satisfies the test. Back to our example where individuals must be 21 years or older in order to legally consume alcohol. Let's say that someone who is 19 years old wants to challenge that law and say that it's unconstitutional. He's being discriminated against because of his age. He files an equal protection clause. What standard of scrutiny will the court have to employ? Well, this individual is claiming that the classification is age. Your book clearly says that if the individual is alleging that they're being discriminated against because of their age, then rational basis will apply. And the law will be upheld if it is reasonably related to a legitimate government interest. And we can say that the law that requires someone to be 21 years and older in order to legally consume alcohol is reasonably related to a legitimate government interest, which is we don't want a bunch of young people who are under the age of 21 who may not be mature enough to understand the consequences of drinking alcohol. We don't want individuals like that being able to consume alcohol. We want them to be 21 years and older where they are more mature, they can understand the consequences of drinking alcohol, and the world will be a much better place. So the first thing you need to do is you need to be able to identify what level of scrutiny the court should use. And then the second thing you need to be able to do is determine whether or not the law or the regulation is able to withstand the test, whether it must be narrowly tailored to serve a compelling government interest, it must be substantially related to an important government interest, or it must be reasonably related to a legitimate government interest. I hope that this concept is clear. If in fact it's not, please send me an email and we can schedule a one-on-one where I can try to make this concept more clear. Okay, the next slide is the prohibition on ex post facto laws. Ex post facto is Latin for after the fact. It is laws enacted in order to retroactively punish behavior that was legal once it was committed. It also prohibits changing the punishment after an act was committed or removing defenses available at the time of the crime. Now, your book goes into great detail about ex post facto laws, and it lets you know that just as the 14th Amendment requires equal protection, the US Constitution bans so-called ex post facto laws. Okay, so the US Constitution has banned this, so you can no longer enact a law today that punishes behavior that was legal at the time when the act was committed. Okay, so there's an example here in your book that I found to be very illustrative of this. It says, assume that a state decides to define a juvenile as someone under the age of 16 and not the usual 18, right? So now the law first said that you're a juvenile if you're under the age of 18. But then they changed it and said a juvenile is someone under the age of 16. So let's assume that a 17-year-old committed robbery before the change. So when this 17-year-old committed robbery, he or she was a juvenile because at the time they committed the robbery, they were under 18. But now the law has changed. The law now says a juvenile is someone under the age of 16. So now this 17-year-old is no longer considered a juvenile. So to suddenly try him or her as an adult, it could constitute an ex post facto violation because at the time he or she committed the robbery, he was 17, which is under 18, which makes him a juvenile. But now the law has changed, making a juvenile someone under the age of 16. So can we now punish this person as an adult? I don't think so. Because at the time they committed the crime, they were a juvenile because a juvenile was someone under the age of 18 and this individual was 17. So that is an example to give you an idea of an ex post facto law that has been prohibited by the Constitution. All right, the next limitation on criminal law is void for vagueness. If so criminal statutes, they must be drafted with clarity and specificity so that an average citizen knows what conduct is prohibited. If, for example, a criminal statute stated only that it is a crime to be bad, it is a crime to be bad, citizens would be left to wonder exactly what conduct was prohibited. The U.S. Supreme Court has repeatedly struck down laws that are so vague that a normal person could not reasonably understand them or determine when they can be applied. These types of cases are normally seen in situations that are based on the Fifth and 14th Amendments due process clauses. Void for vagueness cases have historically fallen into two categories: those dealing with obscenity laws and those dealing with loitering and vagrancy statutes. Your book made a very good example or listed a very good example of a void for vagueness case in State versus Metzger. That case was a situation where the Nebraska Supreme Court was tasked with deciding whether a Lincoln City ordinance was void for vagueness. Now, the law in question provided that it shall be unlawful for any person within the city of Lincoln to commit any indecent, immodest, or filthy act in the presence of any person, or in such a situation that persons passing might ordinarily see it. The defendant in that case, Metzger, was observed standing near his apartment window naked, and he was convicted under this statute. He argued that nudity is not necessarily obscene and is a form of free expression guaranteed by the First Amendment. Now, he also argued that the ordinance was overly vague. The court, who focused on the vagueness issue, noted that there is little agreement as to what constitutes an indecent, immodest, or filthy act. So, in other words, Saying that something is indecent or immodest or filthy without any further specificity makes that statute very vague, and people won't really know what type of conduct is prohibited just by seeing that indecent is prohibited, immodest is prohibited, filthy is prohibited. Without any further specificity, we don't know what's prohibited, because what's indecent to me may not be indecent to you. What's immodest to me may not be immodest to you. So this is what the courts try to or this is what they will consider to be unconstitutional if it's something that can be left open for interpretation. Courts don't like that. So in that case, the court said that there may be those few people who believe that persons of opposite sex holding hands in public are immodest, and certainly more who might believe that kissing in public is immodest. Such acts cannot constitute a crime. Certainly, one could find many who would conclude that today's swimming attire found on many beaches or beside many pools is immodest. Yet, the fact that it is immodest does not thereby make it illegal, absent some additional requirement related to the health, safety, or welfare of the community. The dividing line between what is lawful and what is unlawful in terms of indecent, immodest, or filthy is simply too broad to satisfy the constitutional requirements of due process. Both lawful and unlawful acts can be embraced within such broad definitions. And for that reason, the court found that statute to be unconstitutional because it was too vague. And then there's the other situation with the vagueness of these statutes, is that they can arbitrarily, the law can be arbitrarily applied based on the discretion of the police. So let's say that I'm just based on the statute that we just read from the Metzger case, let's say that I was with my significant other in public and we were kissing in public, and the police officer felt that that is immodest or indecent or filthy, then he would be able to arrest me for that. Whereas, let's say another police officer may not find that to be immodest or indecent or filthy because it's conduct that he or she engages in on a regular basis. So we cannot have laws that are being arbitrarily applied based on the discretion of police. They need to be listed with clarity and specificity so that the person being charged can know the conduct that is being prohibited. Then there is also the void for overbreadth doctrine. In general, a law will be void for overbreadth if it prohibits action that is protected by the Constitution. So, for example, a law that criminalized starting a riot and saying anything bad about the President of the United States would be overly broad and unconstitutional. Now, while it is permissible to outlaw starting a riot, the ability to peacefully criticize our politicians is protected under the First Amendment and cannot be criminalized. Overbreadth cases, they frequently involve the First Amendment, which protects the freedom of religion, assembly, and speech. But it is the latter, the protection of the speech, that is really going to be of interest to us when we're talking about the void for overbreadth doctrine. In general, Congress cannot ban free speech. And everyone is always, saying that, oh, I can say whatever I want to say, freedom of speech, freedom of speech, freedom of speech. But that is not correct. Okay. So while Congress cannot ban free speech,